fans.
Good day, everyone, and welcome to our podcast. I'm Yash, and today we are discussing a contract law case that is highly relevant for anyone running a business. The case is Butler Machine Tool versus XLO from 1979, decided by the English Court of Appeal. Before we proceed, let me introduce my group members.
Good morning, I'm Tarshni Ganesan.
Hi, my name is Ferici Elton Gornica.
Good morning, I'm Lydia.
Hello, I am Suzy.
Good morning, I'm Lisha.
And I am Ali Imran. I will be managing the visuals for our discussion.
Thank you, everyone. This case concerns what is known as the Battle of the Firm, which occurred when two businesses each submit their own standard contract terms and the terms do not align. This is a classic issue in commercial law. Let us begin with the fact. Darshini, please explain what happened.
Certainly, Butler Machine Tools made an offer to sell a machine to XLO. In Butler's quotation, they include a price variation clause. This clause allowed Butler to increase the price if their production costs rose before delivery.
So, the final price was not fixed at the time the offer was made?
Correct. The price could increase. XLO did not accept that condition. They respond with their own purchase order, which contained no price variation clause. It started with a fixed price only.
So, what the buyer was effectively saying, we will pay this amount and no more?
Precisely. Attached to the purchase order was an acknowledgement slip. XLO instructed Butler to sign and return the slip if they are agreed with the buyer's terms.
And the butler did sign it?
Yes, Butler signed and returned the slip. However, Butler also sent a separate letter stating that they were proceeding under the original quotation. This created a conflict. On one hand, they signed XLO form. On the other hand, they claimed to be bounded by their own terms.
So, there were two conflicting documents. Which one is legally binding?
That is exactly what the court had to decide. Eventually, Butler delivered the machine an attempt to charge extra under the price variation clause. XLO refused to pay the additional amount and the case proceeded to the court.
So, the core distributor was which set the term from the binding contract?
Yes.
Thank you, Darshini. Now that we understand the fact, we must consider legal principles that determine which term prevail. Ferici, please explain the legal issue and connect English law with Malaysian law.
With pleasure. So, from a legal perspective, the court has to resolve several key questions. Although this is an English case applying an English common law, Malaysian contract law is substantially similar because the Malaysian Contract Act 1950 was largely differed from English common law principles. Therefore, we can draw direct comparisons.
This is useful. What is the first legal issue?
The first issue is whether a binding contract was formed at all. Under the English common law, a contract requires offer and unqualified acceptance. In Malaysia, this same principle is codified in Section 2, subsection A and Section 2, subsection B of the Contract Act 1950.
But Butler's offer contained a price variation clause, whereas XLO's order form did not. This is not an unqualified acceptance, isn't it?
Correct. This is where English law and Malaysia law align. Under English common law, if the offeree changed the terms of the offer, it is not acceptance. it is counter offer. Under Section 7, subsection A of the Malaysian Contract Act 1950, acceptance must be absolute and unqualified. Any modification constitutes a counter offer.
So, XLO purchase order was a counteroffer under both legal system.
Yes, English common law provides that a counter offer rejects the original offer. Malaysian Section 7, subsection A, similars provide that if acceptance is not absolute, it is not valid acceptance. Both systems treat it as a counter offer.
Then, what was the legal effect when the butler signed the acknowledgement slip?
Under English common law, a term must be a part of the binding contract to be enforceable. Under Section 10 of the Malaysian Contract Act 1915, all agreements are contract if they are made with free consent. Since the price validation clause was not included in the final agreed terms, it was not enforceable under legal system.
What about the butler's letter stating they were proceeding under their original quotation?
The court determined that the signature on the slip was the clearest evidence of the acceptance. The letter could not override that document. Under Section 2, subsection B, the Malaysian Contract Act 1950, the same conclusion would be reached. The signed document represents a valid acceptance.
There is also the concept of acceptance by contract, correct?
And yes, under English common law, acceptance can be implied by conduct. In Malaysia, this principle is codified in Section 8 of the Contract Act 1950. Section 8 provides that performance of the condition proposal constitutes acceptance. By manufacturing and delivering the machine without objecting to XLO terms, Butler accepted those terms by conduct under both English and Malaysian law.
Finally, was the price variation caused the enforcement?
Under English common law, a term must be a part of the binding contract to be enforceable. Under Section 10 of the Malaysian Contract Act 1915, all agreements are contract if they are made with free consent. Since the price validation clause was not included in the final agreed terms, it was not enforceable under legal system.
So, the bottom line is that English law and Malaysian law reached the same conclusion.
Yes, whether one applies English common law or the Malaysian Contract Act 1950, the result is identical. The excess or term prevail and the price variation clause is not enforceable.
Thank you, Ferici. We have established that the counter offer principle and the mirror image rule are central to this case, and both English and Malaysian law agree. Now, Lydia, please explain the court actually decision and reasoning.
The Court of Appeal ruled in favor of XLO Butler laws. The court held that XLO's purchase order was a counteroffer, and when Butler signed the acknowledgement slip, they accepted that counteroffer. Consequently, the contract was binding on XLO's terms, and the price variation clause was excluded.
Lord Denning is one of the judges that made an interesting observation. He agreed that in a modern commercial practice, courts should not rely exclusively on rigid technical rules. Instead, they should examine the entire conduct of the parties, including all the correspondence, forms, and action to determine what the party actually agreed upon.
So, Lord Denning adopted a border approach.
Yes, however, the other two judges, Lawton LT and Bridge LT, took a more traditional approach. They held that Butler signed the acknowledgement slip, and that signature was the moment of acceptance. That document constituted the contract.
The key legal principle affirmed Here are the counter-offer principle and the mirror image rule. Acceptance must match with the offer exactly. As we discussed earlier, this principle is consistent with the Section 7, subsection A of the Malaysia Contract Act 1950.
Additionally, the court applied the last shot doctrine. This doctrine provides that the last document signed by one party without objection from the other party prevails. In this case, XLO's purchase order was the last shot.
So the contract prioritizes clarity and certainty over the each party subjectively believed that had agreed to.
Yes, the court looked exclusively at the final signed document, not the early expectation or assumption of other parties.
Thank you, Lydia. Now we understand the court decision. However, most entrepreneurs will never appear in court. Therefore, the practical implication of this case for business owners are more important. Shuzi, please analyze the business impact and the lesson for entrepreneurs.
Alright, thank you, Yash. Let us analyze the impact of this case on entrepreneur and business owner. First, clarity is far more important than many business owners assume. Most companies exchange purchase orders and invoice without carefully reviewing the terms. This case demonstrates that a single clause, such as a price variation clause, can have significant financial consequences if overlooked.
And the battle of the forms can be particularly dangerous for startups that they may not realize they are engaged in once.
Precisely. If a business sends a purchase order that modifies the seller's term, the document is a counteroffer. If the seller then accepts by conduct such as delivering goods, the buyers become bound to their own terms. This can work to the advantage or disadvantage of either party.
So the outcome depends on whether you are the buyer or the seller?
Yes, a buyer generally wants to be the party signing the last document. A seller must exercise caution when signing any document that contains conflicting terms.
Documentation is also critical. Written records are far more reliable than the verbal agreements.
You are correct. In this case, the written documents, including the quotation, the purchase order, the acknowledgement slip, and the letter, were all decisive. The court relied entirely on the written record.
So the lesson from entrepreneur is to read every document carefully and negotiate any unfavorable terms before signing or performing under the contract.
Exactly. Another important lesson is that legal literacy is a business tool. Entrepreneurs do not need to be lawyers, but they must understand fundamental contract principles. Ignorance of the law does not protect a business owner. It only increases the vulnerability.
Thus, this case is not merely about legal technicalities, it is about practical business risks.
Yes, and that is why every entrepreneur should be familiar with this case.
Thank you, Suzy. Clarity, documentation, and legal literacy are the key lessons from the analysis. Now, Lisha, we must consider whether we agree with the court decision. What is your view?
I agree with this decision. My reason is as follows. Butler signed the acknowledgement slip. That was a clearly deliberate act. In contract law, a signature in the document blinds the signatory. A party cannot sign an agreement at late and claim that separately later. Should we overrate that signature?
Legally, this is consistent with the Section 2, subsection B of the Malaysian Contract Act 1950. A signature on a document constitutes a valid acceptance.
However, I can understand why some might disagree. Butler's original quotation explicitly stated that the price could vary. Butler likely believed that this term remained part of the agreement.
That is a reasonable observation. In certain industries such as construction or manufacturing, price variation costly are common because material costly fluctuate. Butler expectation was not unreasonable.
Thank you, Lisha. We agree with the court, but we also acknowledge that businesses can take proactive steps to avoid similar dispute. Ali, please present your recommendation.
Based on this case, I recommend the following measures for entrepreneurs and business owners. First, include a supersede clause in all contracts. This clause states that the agreement supersedes all previous communications. This prevents either party from arguing that an earlier email or quotation remains applicable.
That will effectively eliminate the last shot problem.
Second, train your team. Sales and procurement personnel must understand the difference between an offer and a counteroffer. They should not sign any document containing conflicting terms without first consulting legal counsel or management. Third, for a long-term business relationships, use a master service agreement. This is a single contract that governs all future transactions, eliminating the need for repeated battles of the form.
And for high value contract, always seek a legal review. The cost of legal advice is significantly lower than the cost of litigation.
The overarching principle is to be proactive rather than reactive. Do not wait until a dispute arises to review your contracts.
Thank you, Ali. Those are excellent recommendations. Now let us conclude our discussion. We have covered a great deal today. Before we conclude, I would like each of us to share one key lesson from this case.
For me, the main lesson is that contract requires clarity and not assumption. When you assume something in a business transaction, you expose yourself in risk.
I agree. And my key takeaways is that the battle of the forms is real legal risk. Whether we apply English common law or the Malaysian Contract Act 1950, the principles are consistent. Entrepreneurs must know the section 2, 7, 8, and 10 of the Act.
Documentation is critical. Write everything down. That is why Secure XLO Victory. They had the signed acknowledgement slip.
Legal literacy is not only for lawyers. Entrepreneurs must understand basic contract principles. Failure to do so can result in significant financial loss.
If you want to consult include in your contract, ensure it appears in the final signed agreement. Do not rail on the early email or quotation. It was a Butler mistake.
Be proactive. Review your contracts before signing or performing. Do not wait until you are in court to discover the terms you have agreed to.
Well said. As for me, the lesson is always read the fine print, as this case demonstrates the fine print matters. Now, allow me to offer the final conclusion. In summary, Butler Machine Tool versus XLO demonstrate that in contract law, the final signed document is decisive. Earlier, assumption, quotation, and letters are not binding if they conflict with the final agreement. The court apply the counter offer principle and the mirror image rule. We have seen that both English Common Law and Malaysia Contract Act 1915 reach the same conclusion. For entrepreneurs, the lessons are clear. Be precise in your negotiation. Document every agreement. Never assume that terms carry over from an earlier document. If you wish to include clause, ensure it is explicitly stated in the final signed agreement. And when in doubt, seek legal advice. This case reminds us that legal literacy is not merely a professional requirement for lawyers. It is a strategy business tool. Thank you everyone for a productive discussion. We will see you in next episode. Bye bye.